after you file an answer to a lawsuit, you may have already filed an answer and you're like, okay, what to expect next? Or you're like, I need to file an answer and I'm just trying to get up on what to do next, right? Before we get into the video, this is not legal advice. If you need legal advice, please consult with a licensed attorney. All right. What filing an answer actually does. All right, once you file an answer, the case changes, right? Before that, they may have been counting on you not to respond as they normally do, right? If that happens, they can try to get a default judgment because nobody challenged the lawsuit. So once you answer, that easy route gets interrupted, right? So now they know you're paying attention. Now they know they may have to actually prove the case through the court process, and that they might have to support what they claimed in the complaint instead of just filing papers and hoping you stay silent, right? Your answer also protects your rights to defend yourself. It puts you in a position to challenge the balance, challenge things like the challenge ownership, the timelines, whether they even have enough proof, right? That's why filing an answer matters so much. You're pretty much no longer someone they expect to ignore it. Now you're someone that they actually have to deal with properly, right? So you're officially in the fight now when you answer. All right. What usually happens next? So after you file an answer, a lot of people think something dramatic happens the next day. Not always. Sometimes nothing happens right away. The case may sit for a little while. That does not mean it disappeared. It just means the next step has not happened yet. Other times, they may schedule a hearing, send paperwork, reach out to discuss settlement, or file like motions with the court. They may also start preparing to prove. I meant to say prove, y'all. They may also start preparing to prove their case now that they know you responded. Every court moves differently, by the way, and every plaintiff moves differently. Some move fast, some drag cases out. Some were only expecting a default and now have to decide if the case is even worth pushing. That's why after you answer, it's important for you to stay alert, right? Keep checking your email, keep checking the docket, keep your paperwork organized, right? Because once you answer, the case becomes active and the next move could come at any time. And also going back to the way that it's handled, you also want to be privy to whatever court that is filed in. You want to be privy to your court's rules and procedures, right? Because that's important too. Like a lot of the times cases get dismissed because the rules of civil procedure weren't followed the correct way. So that's very important too. They may try to settle, right? Once you file an answer, some collectors start looking at the case a little bit differently, right? Because now, again, it's moving from that, oh, we thought you were going to ignore it and they get an easy judgment. Now they know you responded. Now they know that it's time to make a decision, right? Like you got to make time, like show the proof. And this is where settlement offers sometimes start showing up. They may offer payment plans. They'll offer reduced lump sums. And they'll even talk about dismissing the case if those terms are met. That does not automatically mean they are being generous. Sometimes it just means they are weighing the cost of continuing the lawsuit. If they have a strong case, they may still push forward. If the file has problems, settlement can become more attractive to them. So if settlement comes up, that's normally what it's about. So read everything carefully, right? Understand whether the case would be dismissed without prejudice or with prejudice or without prejudice. That's important too, because that determines whether you can follow up with it at a later date. And everything else, right? Keep it simple, right? Trying to settle is one of their last tactics, more than likely, because they don't want to pursue the case, especially if it's a high amount. Why would I settle when I have all of the proof, I have all of my ducks in a row, and I'm coming in here? Why would I want to settle? So you have to be strategic. Like you have to think, man, they settle it because they ain't got all their ducks in a row, right? They may need proof now, right? And it kind of piggybacks off of the last slide, right? Once you file an answer, the case is no longer just paperwork sitting on a desk. Now they may have to back up what they claim, right? If they said they own the debt, they need records showing ownership. If they said you owe a certain balance, they need to show documents showing how that number was calculated. If they sued the right person, right? They may need records tying the account to you, because a lot of the times these debt collectors will go in these cases and it'll say, yeah, we purchased some debts, but your specific account is not listed in there, right? If the lawsuit was filed on time, right? This is pretty much the point where cases can start showing some problems, right? Maybe the balance doesn't match, the ownership records are incomplete, the dates raise issues, right? Maybe they expected no response and were not prepared to go further, so they don't have much of anything, right? That does not mean every case falls apart. It just means once you answer, they need more than allegations. They need actual proof. All right. Court dates may be scheduled. After you file an answer, the court may start setting dates. That could be a pretrial conference, a status hearing, a motion hearing if you guys are putting in motions, a trial date depending on the court. Some hearings are just simple check-ins. Some are for scheduling. Some are for settling discussions. Some are serious hearings, though, where, again, issues can be decided. Do not assume every court date means trial, but do not treat any court date casually either, right? Read every notice carefully. Look at the date, look at the time, the courtroom, whether it's in person, by phone, is it virtual, right? If you miss a scheduled appearance, that can hurt your case significantly. So once you answer, stay on top of your mail. If stay on top of your email, if you provided an email, and stay on top of the court docket as well. A lot of people file an answer and relax too early. Don't do that. The next phase often starts with court notices. All right. Some cases stall out, right? After you answer, the case slows down. That can happen for different reasons. They may be viewing whether the case is worth pursuing. They may be waiting on documents. They may transfer the file to another attorney. They may have a large volume of cases and yours is, no longer an easy default, right? They may also realize they need more proof than they expected because of what you're asking. This does not mean you won. It does not mean the case disappeared either. It just means the case may be paused or delayed. Or just moving a little slower than an easy win, right? That's why you don't assume silence just means safety, right? You're not in the clear. Keep checking that court docket. Keep your paperwork organized and keep watching those deadlines, right? Biggest mistake after answering. One of the biggest mistakes people make is thinking, I filed my answer, so now I'm good. No, right? Filing the answer is literally just the beginning of the defense process, not the end, right? So some people answer the lawsuit, then stop checking their mail, they miss court dates, they ignore motions, and then they wind up with a default judgment. And then they're looking like, oh my God, what happened? How did this happen, right? And that can put you right back in a bad position, right? So now you didn't even get an opportunity to plead your case. Now the judge has already decided because they only had one side to go off of because you never showed, right? You still need to stay involved. Again, watch your mail, check the court docket, track those deadlines, read anything the plaintiff files, right? If they schedule a hearing, know about it. If they file a motion, deal with it. If they send discovery, respond properly, right? The mistake is thinking one filing handles the whole case, right? It doesn't. It's a continuous cycle, right? The answer pretty much opens the door. They knock, you open the door, and then what you do after that, it still matters. It's not the end, right? So let's talk about what you should be doing. This is the time to get organized, right? Keep every paper related to the case in one place, right? Save any envelopes, any notices, any emails, and anything that you receive in general, right? Start building your timeline. When were you served, right? When did you file? What has been sent since then, right? Pull any records you have that relate to the account, right? That could be statements, payments, confirmations, right? Any settlement letters, emails, any old correspondence. It doesn't have to be anything new, but anything related to this case, right? Because again, they're going to pull out all the bells and whistles against you if they keep the case going, right? So keep checking the court docket so nothing catches you off guard. And again, start learning the next phase of the case, whether that is discovery, motions, settlement, hearing preparation. This is where people kind of separate themselves from, they answer and kind of go back to sleep, and then others answer and start preparing, right? That's the difference. The second group of people, which is those people that get up and start preparing, usually do much better, right? Because that's where the strategy begins. What we teach inside the community. Once you file an answer, the next question becomes, now what? Right? That's where most people get lost. They answer the lawsuit, but they do not know how to challenge evidence, how to request documents, how to respond to motions, or how to use leverage the right way. So inside of my community, we go deeper into the next phase. We break down discovery requests so you know what to ask for and why. We go over motions and how to respond when the other side files them. We teach to examine ownership claims, balances, timelines, weak records. We cover settlement strategy when it may make sense, which the 99.9% of the time is not going to make sense. How to walk just pretty much when you've already stepped into the door and you don't know what to do next, right? So the goal is not just to answer the lawsuit. The goal is really to understand the full process and know how to move through it confidently, because if you don't, you're going to be caught off guard every single time, right? So again, and we think, oh, well, they're filing, people don't know what to expect after they file an answer. So a lot of things catch them off guard. Again, like notices, like, if they submit into discovery, bank statements or billing statements, how do I respond to that? What do I look for in discovery? How do I go over the evidence that they have against me? People get stuck at that point, and that is what the community is for. If you are interested in joining the community, make sure you click the link in the description below and join the community. It's lit over there. We have conversations. We have weekly lives. The weekly lives will start after the mentorship. So if you are in the VIP, you have access to the mentorship plus the mentorship replays. And premium tier is getting the mentorship links, just not the replays. So if you want to be a part of the mentorship and you take great notes, make sure you join the premium tier and upgrade, especially if you're dealing with something like a court case. All right, so that is the end of this video, and I will see you guys in the next one.